Okay. All right, I'll call the August 25th, 2020 study session to order. Madam Clerk, roll call, please.
The record will reflect that all members of council are present.
All right. First item is clarification of items on the consent calendar. Mr. Herdman, do you have any items that you'd like clarification on? Mr. Duffield? Ms. Brenner? No. Ms. Dixon?
Nope.
Mr. Muldoon? All right. Mr. Avery?
Item 10.
Okay, so item 10 is the assessment district number 111 and underground utilities district number 22.
I'm going to excuse myself, Mr. Mayor, due to conflict. Thank you.
Go ahead.
I also need to recuse myself due to real property interests.
All right. So just a second, Mr. Webb.
So I'm a fan of undergrounding for a variety of reasons, and I just think this is a big number item. Obviously, looking at it on consent, just a little explanation and where the money's coming from.
So this item tonight has to do with a continuation of undergrounding of Balboa Boulevard. If you recall, we just did phase 1 from Coast Highway down to about 36th Street. In this project tonight is phase 2 that goes from 36 down to about 21st, depending where the boundary on phase 3 is. And also it has a residential 20B undergrounding district right along the ocean side included, and that's why the big numbers there. We have 28 funds, which are city-directed funds. The council gave us direction how to spend that. We have resident funds coming in, too, to pay for their portion of the undergrounding.
They've been waiting for a while.
They've been waiting quite a long time. We've had a lot of great, in Diane's district, a lot of success on the other side. Those 116 districts that just got done, and a lot of happy people. We're looking forward to getting this one done. Plus, it'll really help clean up McFadden Square, a lot of poles and everything up in the commercial district there.
All right, welcome back to the August 25th, 2020 regular City Council meeting. Madam Clerk, roll call, please.
The record will reflect that all council members are present.
So we'll move on into public comments on non-agenda items.
Thank you for the time today. I attest and affirm the following statements are true, accurate, and within my personal knowledge. Thank you. There was a game-changing ruling on August 12, 2020 in the Ninth Circuit Court of Appeals regarding FCC 18-133. That's the FCC order for streamlining small cell deployment. On August 12th, the Ninth Circuit judges wrote, quote, Congress prohibited unreasonable discrimination but permitted state and local governments to differentiate in the regulation of functionally equivalent providers with very different physical infrastructure. Those would be small cells. We therefore hold that the FCC's requirements in the small cell order that, quote, aesthetic regulations be no more burdensome than regulations applied to other infrastructure deployment is contrary to the controlling statutory provision. They also continued, we also hold that the FCC's requirement that all aesthetic regulations be, quote, objective, end quote, is not adequately explained and is therefore arbitrary and capricious. This is very important. We need to unpack this. This means the city of Newport Beach, under the cooperative federalism scheme that was set up by the 1996 Telecommunications Act, is a full player in local regulations over so-called small cell wireless telecommunications facilities, including the operations of these WTS. That means the effective radiated power. Here's the problem. If you have a properly sited macro tower, 2,500 feet away from people, with antennas 200 feet in the air, when the signal gets to a bedroom, it's enough for 5 bars on a cell phone. That's 0.002 radiation units. However, when you put a small cell 50 feet outside of someone's home and turn it on, in that bedroom is now 50,000 radiation units. Folks, that's 25 million times higher. That is a matter of public safety. You have to understand you own this as the city council. So we have a conference report from the 1996 TCA which says specifically that the conferees do not intend, if a state or local government grants a permit in a commercial district, it must also grant a permit for the competitor's 50-foot towers in a residential district. This is about public safety. You all own public safety. Neither the FCC nor the wireless industry own it. It's all yours. The congressional intent of the 1996 TCA was to not construct small cells in residential zones. Full stop. Wireline broadband by copper, coaxial, or fiber optic cable is not a functionally equivalent service to any wireless service, either wireless telecommunications service, that means phone calls, or wireless information service, that's internet gaming or video streaming.
Thank you very much.
Thank you.
All right, next speaker, please. As we head into item number 17, there are a few of us that need to declare conflicts, and I will start. I have to declare a conflict because AT&T has worked with Ericsson on their telecommunication poles. I previously disclosed this conflict because I represent Ericsson. I am an attorney. They're one of my clients. And so I will be declaring a conflict on this item as well.
I need to also because of financial interest.
And I have a conflict because of my prior employment in telecommunications. Thank you.
So for the appeal this evening, we will hear a staff report summarizing the issues for consideration by City Council, and then we will hear from the applicant, who will be given 15 minutes for its presentation, and then we will hear from the appellant, who will be given 15 minutes for his presentation. And then we will hear from the public, and finally the applicant will be given 5 minutes to address any issues raised before the public hearing is closed and the matter is returned to City Council. Before we get into the substantive issues related to this appeal, it is my understanding that there are some procedural issues that we should be aware of for this hearing. Mr. Hart.
Thank you very much. Just given the limited number of council members available to consider this item, I think it's important for the City Council and public to know that under the City Charter, to pass any resolution, the Charter requires 4 affirmative votes. 4 votes are not received in support of a motion. This technically results in no action being taken, and a new motion can be made. If after exhausting all the motions, there's not the required number of votes to approve any resolution, the original decision of the Planning Commission would be the operative decision. So to take action tonight, you have to have all 4 votes. That's it in sum.
Thank you. So I'm going to go ahead and open the public hearing. Mr. Sadeba, could you please summarize the nature of the hearing and the issues to be resolved by City Council?
Good evening, Mayor Pro Tem Avery and council members. Ben Zadiba, Senior Planner with the Planning Division. I'll give you a brief project overview of what's before you this evening. And as you said, there are other speakers, so I'm not going to go into it in extreme detail. I'm going to keep it higher level. So once the PowerPoint boots up here, I'll have a better outline for you. But I would also note that I have the real property administrator for the city, Lauren Whitting-Whitlinger, with me if you have any specific questions about the license agreement for that particular streetlight pole. I can go ahead and kind of start before that comes up, since we're not seeing the presentation. But basically before you is the appeal of the Planning Commission's approval of a minor use permit and a coastal development permit to install, or to allow the installation rather, of a small cell wireless telecommunications facility on top of a existing replaced rather streetlight pole. This particular location, if I may go to the next slide here. Let's see. There you go, okay. So the location is on the corner of 30th Street and Balboa Boulevard. You can see it is shown by the red circle. That is City Streetlight 0796. It's uniquely situated in front of a 20-foot wide parkway that the city owns and maintains. Now, to step back and give you some background, I would just go ahead and throw into context that the city's review is largely limited by federal law. That is to say that federal law regulates the emissions component largely, which is the Federal Communications Commission. They look at the radio frequency emissions. So for the most part, the city cannot make a decision based on perceived health concerns or impacts. In this case, you're looking mostly at aesthetics, land use, and environmental impacts. So as you know, Council authorized a master license agreement with New Singular Wireless in February of last year to have non-exclusive access to streetlight poles for this particular purpose. On April 16th, 2020, the city zoning administrator did approve this application to allow the installation. Subsequently, it was appealed by an attorney, Mark Pollock, who is representing an anonymous resident of Newport Beach, citing concerns with the master license agreement, not with the location itself, mind you. July 9th, it did get heard as a de novo hearing before the Planning Commission, and it was also approved. Subsequently, July 15th, it was appealed, and that's why it's here before you tonight. So the project at hand is to remove that particular streetlight that you saw in the image, replace it in the same exact location. One key component is that the city requires the carrier, or the applicant, to maintain the same luminaire height, which is the light source. So in essence, it shouldn't look much different from a parity standpoint. When you're looking down the street, it should blend right into the streetscape. The overall height increase to the top of the antenna shroud is approximately 4.5 feet. And I would just note that this is a 4G wireless installation at this time. It is not a 5G wireless installation. They'd have to do some upgrades to that equipment and change the design in order to make that a 5G facility. Also, the supporting equipment is completely vaulted below grade, such that you would not see that on the sidewalk. It will not hinder any public access. Again, the idea is it's taking place of an existing streetlight in the same exact location that you see there. As I said, it does require a minor use permit for a public right-of-way installation. It also requires a coastal development permit because it is located within the coastal zone. So just to give you a better idea of what it's going to look like, here's the existing, and I did my best to superimpose the images for you if you give it a moment here. So the block that you see, that's not going to be part of the streetlight. That is showing a potential to house a temporary banner if the city allows a banner installation for the holidays or some sort of special event. That's not part of the proposal. It is just intended to show that it does have that capability. The most notable feature is, again, on top of the replaced streetlight, you will see the 12-inch in diameter antenna shroud that does house the equipment. Again, nothing in terms of wiring or anything antenna-related will be visible outside of that shroud. So as part of staff's analysis and as part of the applicant's requirements, they did look at alternative sites in the area. You'll see a number of them there. I know that the applicant will speak later. I don't know if they'll go into detail on this, but they certainly can if you so wish to hear that. But for the most part, a lot of these are on wooden utility poles, and this isn't an underground assessment district, so they didn't see it as something that was feasible or that made sense for this particular project. Also, the fact that this particular location is in front of a 20-foot wide parkway makes it unique for the area. Most of the utility poles are right up against a residential property, so it was seen as the best and least intrusive location. So although not required, the applicant did provide coverage maps as well. You can see the black dot is the proposed facility location. With the proposed facility online, you can see that there is a substantial increase in coverage for that area. Again, this is not something that was required of the applicant. They provided it to substantiate their request for this particular location. So in terms of findings, in order to recommend approval or approve a minor use permit, coastal development permit, you have to find that it is consistent with the city's local coastal program, which in this case, staff does believe it is. Consistent with the zoning code and general plan, which again, staff believes it is consistent with all of the provisions in the code, as well as general plan land use policies. It is visually compatible. As I said, the luminaire height and the location in front of a landscape parkway make it such that it blends into the streetscape. And lastly, it complies with all Title 20 and Title 21 development standards that are pertinent to wireless telecommunication facilities. In this case, it is less than 35 feet tall. It is 34 feet 9 inches. 35 feet is the absolute maximum for these types of facilities. But the existing streetlight pole, I'll note, is approximately 30 feet tall. So they are working with a taller pole to begin with. All of the equipment is concealed within the pole and underground, and again, alternative sites were considered. So lastly, I'm not going to go into each appeal point. I'll let the appellant talk about that, and the representing attorney or legal counsel for AT&T can also talk about that. But there are three main points to the appeal. Once again, not citing concerns with this particular location, rather calling into question the integrity of the master license agreement and the applicant submitting the application. So with that, staff is recommending that you conduct a new public hearing, find the project exempt from CEQA, and adopt a resolution to approve the minor use permit and coastal development permit, which will uphold the Planning Commission's decision and deny the appeal. As I said, I'm available for questions. Lauren Wooding-Whitlinger is here as well, and you can roll right into the appellant and applicant presentations if you please.
Thank you. Do we have any questions from council to Mr. Sadiba? No questions? All right, so now we'll hear from the applicant, who will be given up to 15 minutes for his presentation.
Good evening, Mayor Pro Tem Avery and Council. My name is Corey Autry. I work with Wireless Policy Group here tonight representing AT&T. And just to 100% confirm, you would like to hear from AT&T first before you hear from the appellant?
Yes, that's correct.
Okay. Just want to make sure we're on the same page. So I also have with me tonight Judy Woolen from AT&T's External Affairs team, and Franklin Orozco from AT&T's network development vendor. And also on the Zoom call, we have Emily Murray from Allen Matkins, who is AT&T's outside counsel. And I will quickly turn it over to Emily, but first I want to just state that I was very involved in the negotiation of the master license agreement that the council approved in February of 2019. And I can assure you it was not a fly-by-night, overnight sensation. It was an 18-month-long negotiation with city staff, very savvy negotiation with your attorney involved, AT&T's attorney, and many of us business folks. So I just thought it'd be important to, kind of share a little bit of that history. And with that, it looks like we have Emily on the line. So I will turn it over to AT&T's outside counsel, Emily Murray, to talk more in detail about the appeal items.
Good evening, thank you. Can you hear me okay on the Zoom? I'm going to thumbs up on that. My name is Emily Murray. I'm with the law firm Allen Matkins. I'm outside legal counsel to AT&T. I want to just briefly address the legal issues raised in the appeal, and then Corey and team can certainly answer technical questions that folks have about the location, how it was selected, the facility, how it operates, and the like. There were three primary points made by the appellant, legal arguments made in the appeal. The first is that the party to the master license agreement is not the same as the applicant. The master license agreement was signed by New Singular Wireless PCS LLC, and on the application, the party signing the application is AT&T Mobility on behalf of New Singular Wireless PCS. AT&T has provided to staff the recorded fictitious business name statement filed with the county clerk for Orange County that indicates that those two entities are the same, that AT&T Mobility is a fictitious business name for New Singular Wireless PCS. So that entire argument is just a red herring. They are the same entity, the party to the master license agreement and the party who submitted the application. The second legal argument was that insufficient proof of insurance has been provided to the city. Again, the city attorney and city staff have confirmed that they've received all necessary documentation to confirm that the applicant is properly insured, particularly with regard to EMF. AT&T is a self-insured for pollution coverage, which includes hazardous material and EMF. So again, there's no legal validity to the arguments around insurance. And the final argument is really functionally, I think, the same as the first argument. The city's code requires that an applicant enter into a master license agreement with the city. In this case, AT&T, the New Singular Wireless, entered into the master license agreement. That is the same entity as the applicant, AT&T Mobility. So the applicant has entered into a master license agreement with the city and has satisfied those code requirements. So none of these arguments have any legal merit or pose any risk to the city. The city attorney so advised the Planning Commission when the same arguments were presented to the Planning Commission, and those arguments haven't evolved or been restated or they're the same failing legal arguments that were raised below. So AT&T, again, respectfully requests that the appeal be denied by the City Council this evening, and we would be happy, Corey and the team, to answer any questions that you have about the facility itself. Thank you.
Thank you, Ms. Murray. Do we have any council members who have questions of the applicant?
Yeah, this is Corey again. I just wanted to remind the council that we did give a small cell overview presentation when we got the MLA approved. And so we hadn't planned on going into a lot of overview detail, but we're happy to go into detail on the specific location that's before you this evening, although we do feel it was very well vetted by the zoning administrator and also the planning commission. So if you'd like us to go into more detail on how we chose that location, we're happy to do that, but I thought I'd ask before we just spent the time on that.
Any questions? No questions.
Thank you.
All right. No other comments from the applicant? We'll be coming back to you.
Thank you.
So now we'll hear from the appellant, who will be given up to 15 minutes for their presentation.
Thank you.
Go ahead, Mr. Pollack.
Can you hear me?
Yes.
Good. Good evening, Mayor and members of the council. My name is Mark Pollack, and as has been explained by staff, I represent a citizen of Newport Beach who has preferred to remain anonymous for fear of retribution by filing this appeal. I have appealed the decision from the zoning administrator on this deployment to the Planning Commission. The Planning Commission sustained the decision of the zoning administrator, and I now bring the issue to you. This particular appeal is not in the nature of an opposition to the deployment and placement of the technology. Rather, it's to scrutinize the way the permit was issued because of our collective concern about the liability of the city in the event that the placement ends up injuring someone, causes fire, or some other problem potentially related to EMF exposure. So initially, if I may walk you through, I provided written materials to each member of the council, and there are exhibits attached. As Mr. Autry pointed out, the master license agreement is required for placement of the technology on city property. This pole is city property. There was a master license agreement crafted consistent with Title 20.49.080. And as Mr. Autry pointed out, it was signed by the entity which was identified on it as New Singular Wireless PCS LLC. It did not list a DBA. It did not list a fictitious business name on that master license agreement. You can see by looking at Exhibit A attached behind my brief, it says New Singular Wireless PCS LLC, a Delaware limited liability company licensee. It does not list a DBA. The reason that this is important from the city's perspective is that consistent with this master license agreement, the licensee under the agreement indemnifies and holds the city harmless for liability. In addition, it must provide a general liability policy of insurance. And the city has requested that that particular policy of insurance not exclude EMF coverage under a pollution exclusion. So when the zoning administrator issued the permit was not issued to AT&T Mobility. It was simply issued to AT&T. That's not consistent with the master license agreement. Even if AT&T was a DBA, AT&T is not a corporation in California. AT&T is not an LLC in California. If you look at Exhibit B, this is the Secretary of State's information filed by New Singular Wireless PCS LLC. If you go down to item 5B, you will see that the manager of that company is AT&T Mobility Corporation. That's not a DBA. That's a Delaware corporation. AT&T Mobility Corporation is not registered to do business in California. AT&T Mobility Corporation cannot legally do business in the state of California. So if you look at Exhibit D, which is the fictitious business name statement provided by the company to staff on this matter, you'll see that the signature at the bottom right for the entity that submitted it and filed it was a corporation that cannot do business in the state of California, AT&T Mobility Corporation, manager. This document is void. It has no legal authority. AT&T Mobility is not a legal DBA for New Singular Wireless PCS LLC. All that I was asking this entity to do, the Planning Commission, and before them the zoning administrator, was to correct the permit and put the permit in the name of the entity that signed the master license agreement, New Singular Wireless PCS LLC. By doing that, we would ensure that the indemnity provisions of that document are legal and enforceable. Right now, they're not. Moving on to the issue of insurance, I did a Public Records Act request as part of pursuing this appeal, and I was astounded. If you'll turn to the three emails which I've attached as F1, F2, and F3, on F1, Fauna Schrago from the city requested a full copy of the entire policy of insurance from New Singular Wireless PCS LLC. And that request was made on behalf of the risk manager for the city, so they could evaluate the exclusions and limitations on coverage. If you turn to F2, you get the response from Dan Bosnilik, the senior technical manager for AT&T Mobility. He says, Fauna, I left you a voicemail last Friday. We reached out to our risk management group regarding this issue. Unfortunately, AT&T is unable to issue a renewal certificate of insurance prior to the renewal date. AT&T renews every year at the same time. The certificate does not expire until June 1st, 2020. So when the certificate expired, they obtained a new certificate, and that certificate now is in the name of New Singular Wireless. Then the next paragraph is very telling. We did confirm that AT&T is self-insured for pollution coverage. We do not produce copies of AT&T's insurance policy because it is confidential and proprietary in nature. So the risk manager never got to see the policy. It was never produced. If you turn to the next email, this email at the top is authored by Corey Autry, who is there this evening and who presented before I was given an opportunity to speak. Mr. Autry says, hi, Fauna. I wanted to provide you additional information we obtained from AT&T's risk manager. Yes, AT&T always self-insures for pollution coverage. And he goes on to talk about the pollution coverage and the self-insurance. And then he says, we are insured for EMF, period. No proof has been provided to the city that EMF coverage exists or in what amount. No proof has been provided to the city that self-insurance by AT&T provides coverage for pollution or that there is no exclusion under the existing policy. If you turn to the next item, which is Exhibit G, this is the Certificate of Property Self-Insurance provided by New Singular Wireless LLC to the city. It does not list pollution. It does not list EMF. It says flood, earthquake, business interruption, and loss of rents. Accordingly, this entity has not provided your city with proof of adequate insurance as requested by your own risk manager. It has not complied with the terms and conditions of the master license agreement. And my recommendation to this body would be that the matter be sent back to the Planning Commission and that AT&T or AT&T Mobility or New Singular Wireless LLC resubmit the application under a proper name so that the city can be assured that the indemnity provision is in force and effect, and further that AT&T or AT&T Mobility or New Singular Wireless LLC provide a copy of their policy of insurance with copies of exclusions and proof of self-insurance for EMF coverage and pollution. And on that basis, I would submit it. Thank you for considering my position. And I would just ask that if individual council members speak, could you please identify your name, because I've got a court reporter transcribing this proceeding. Thank you very much, ladies and gentlemen.
Thank you. Do any council members have questions for Mr. Pollack?
I have a question for the city attorney. Do you want to comment on those assertions that Mr. Pollack has made? My name is Diane Dixon.
Yeah, so we've taken a look at all the arguments that were made, and we've gone over them with staff, and we think the entity is a proper entity. We think the insurance is proper. We don't see any legal issue here. I think you can make all the findings that the Planning Commission made and uphold their decision.
Okay, thank you very much.
Any questions from council? So we'll now hear from the public, who will be given up to 3 minutes each to make comments.
Thank you for my time tonight to support the appeal to make sure you deny this small cell facility, because there are many problems with this application and it remains incomplete to this day. I have studied the application files intensely. In fact, I'm very experienced at this. We have now over 200 complaints to the FCC for a very common issue, and that is that these things are going forward without required NEPA review. And so it's very simple to take the calculations to figure out whether or not NEPA review is needed, and in this case it is. And unfortunately, NEPA review doesn't exist here, so you cannot actually issue this permit until there's NEPA review done by the applicant. Here's the rule that we're talking about. It's Title 47 CFR, Section 1.1307B. And they talk about exactly what is needed when an antenna is less than 10 meters from the ground. They mean the lower edge of that antenna. And the total power output of all channels is greater than 1,000 watts of ERP. Well, this turns out to be a Galtronics antenna that's very common. They use it in different cities, including Mission Viejo. And you add that all up, and you see that you have 10 ports. And you look at the maximum output from that's capable for the antenna and multiply it by its antenna gain and add it all up. 4,970 watts of ERP. That is over just about 5 times greater than the requirement for the rule, greater than 1,000 watts ERP. Now we just take out a tape measure and we say with a pole that's 34 feet 9 inches tall, you subtract 24 inches for the height of the antenna, you're 32 feet 9 inches. That is below 10 meters. Bing! You qualify by rule. There's nobody's opinion here. This just must happen. And so this one actually will also be reported to the FCC, and we will make sure that every applicant follows proper procedure when they actually want to put small cells in. The reason you want to do this is when you have 5,000 watts ERP literally feet from people's homes, now you have to take a look at what are the frequencies. They said they were 4G only, but actually the antenna can do more than that. In fact, they have 5G frequencies on this antenna. And so those are 3550 to 3700 and 5150 to 5925 megahertz. So even much of the application has fraudulent information in it, and they try to hide that information from you. And this is what they're in the business of doing every day. They're trying to bamboozle city councils into believing that this is a small cell. Hey, the only metric that matters is how many radiation units you have in your bedroom. That's what matters. And when you get compared to a macro tower, you should have something that gives you 5 bars on a cell phone. That would be 0.002. What this one is going to do, it's probably less than 50,000. It's probably going to be like 25,000. But heck, you know, that's still 12.5 million times more. That's not necessary.
Thank you. All right, seeing none, I'll close the public hearing, and the matter returns to council.
The appellant gets a 5-minute rebuttal. I'm sorry, the applicant gets 5 minutes rebuttal.
If the applicant gets 5 minutes for any rebuttal to that last comments.
I'm not sure. The speaker referenced NEPA, which is the National Environmental Protection Act. That's a federal law that applies to federal agency decisions and not to state and local government. CEQA applies in California, as I'm sure you all know. I won't otherwise respond to that comment. I'm not sure I followed all of it. I think I've already addressed the legal arguments. There's nothing new to report there, and we concur with the city attorney's assessment. Corey, do you have anything further to add?
I was just responding to Mr. Mosier's comment regarding why we can't go on private property. And it's not that mechanically small cells wouldn't necessarily work on private property, but it boils down to two major items. One has to do with the fact that we have rights to be in the public right-of-way. There are a number of laws that support AT&T's access to the right-of-way. I won't go into all of them. So that's, you know, we don't have rights to be on all these different private properties with this technology. And the other major reason is the RF propagation doesn't work the same. If we use infrastructure in the public rights-of-way on utility poles and light poles, then we're designing these at a consistent antenna height. And we're also able to propagate that antenna signal in a 360-degree pattern around the pole, and it really lends itself. Small cell technology is best deployed in the public rights-of-way. So just to answer to Mr. Mosier.
Thank you.
Sure.
Council, do we have any discussion?
I'd like to make a motion. May we? Are we at that point?
Yes, we are. I'd just like some direction, Aaron, to make sure we're clear on.
I'm sorry, what's that? No. So you close the public hearing, and then we'd be ready for a motion if there's no items to be discussed.
Public hearing is closed. And now you can.
All right, I'd like to make a motion to uphold the decision of the Planning Commission approving the minor use permit.
I'll second the motion.
All right. All those in favor, please vote.
The motion carries 4-0.